Section 0.1, Introduction. I thank this honorable court for the opportunity to finally obtain justice. While it is regrettable that this process has taken 4 years, I am grateful that this day has finally arrived. I appear not only on my own behalf, but for numerous Canadians whose benefits were similarly denied because of systemic errors, breaches of procedural fairness, and other defects outlined in this case. To be clear from the outset, we are not asking this court to assess the reasonableness of any employer's policy. And we are not advancing arguments about human rights, medical issues, or scientific questions. Our objective has always remained the same: to ensure the EI Act is faithfully applied as written. When determining EI benefits entitlement, decision-makers must conduct the just cause analysis mandated by Section 29(c) of the Employment Insurance Act. This includes assessing whether the employer acted contrary to law, imposed significant changes to essential terms of the employment contract, or exerted undue pressure on workers to leave their employment. The central question is therefore straightforward: was the employer's response lawful? If not, then Parliament is clear: EI benefits must be granted. This also applies to unilaterally changed contracts. However, during the pandemic, federal agencies implemented new internal processes that, in practice, led decision-makers to act contrary to the EI Act. Purported precedent was misquoted or selectively applied, established legal definitions and long-settled tests were displaced by internal policy directives, and logical errors and misstatements of fact and law were embedded into standardized decision templates, creating an entirely new and unlawful benefits decision framework applicable only to a targeted subset of claimants. In total, 15 distinct errors were identified across 7 categories. All but one directly pertained to the EI adjudication process itself, and were unrelated to the circumstances surrounding my former employer. Our esteemed Supreme Court holds that determining legislative intent can involve a RISO analysis of the relevant statutory sections, an exercise that, to our knowledge, had never previously been done using the modern principle of statutory interpretation. The provision at issue represents the most contentious amendment in the history of the EI program, generating more than 4,700 pages of Hansard debates and committee transcripts, and nearly 550 parliamentary references across 3 bills between 1988 and 1996. Parliament's intent was unequivocal: just cause was to serve as the governing criterion for determining EI eligibility, and that expressly included contentious separations in which employers allege misconduct. Despite this clarity, and even though this test was applied more than 1,000 times in the 6 years preceding the pandemic, it was removed from the adjudication process during it, and this has now been effectively enshrined as precedent. Based on this record, expert financial analysis estimates that nearly 500,000 claimants were unlawfully denied more than $12 billion in benefits to which they were legally entitled, which was about half of the EI operating account. EIOA. I recognize the seriousness of the remedy being sought, and its potential implications for the broader system. However, declining to grant this relief would effectively legitimize the sequence of errors at hand, and entrench an unjust and unreasonable precedent that would bind EI decision-makers for many years to come. Section 0.2, Fairness Problems. I must begin by addressing serious concerns regarding procedural fairness. I accept that my written submissions required major reduction from approximately 190 pages, 360 paragraphs plus 271 footnotes, to 30 pages and 85% loss, but I understood that the hearing itself would allow me to present the full substance of my arguments. No party objected to a 2-day hearing at the time, and this remained uncontested until scheduling occurred around Christmas, 6 months later. The respondent then made an unprecedented request. They sought to shorten the requested hearing length from 2 full days to 2 hours. It was argued that this was much longer than other EI benefits judicial reviews, despite none of them raising the precedential, systemic errors that I am. Unfortunately, the Chief Justice mostly granted that request, resulting in another drastic reduction, about an 80% cut in hearing time. While I appreciate that, following my informal objections, the court minimally lengthened this hearing, the time allotted remains far from sufficient to address 15 errors, including a RISO-style statutory analysis involving nearly 5,000 pages of Hansard material, and multiple matters of first impression never addressed by any court before today. As a result, I have been compelled to proceed by reading from prepared oral submissions. This is the only way to ensure that each of the identified errors is properly placed on the record. Once I have completed that task, I will dedicate any remaining time for my reply and for questions from this court. Lengthy interruptions that prevent completion of this record could themselves further impact procedural fairness by denying me the ability to fully present the core of my case. Additionally, I am not a lawyer, and I am understandably nervous arguing complex legal issues in front of this court and so many people. I respectfully request the court's patience and leeway considering these circumstances. I will do my best to answer your questions once I have ensured that all material issues are properly before the court. Thank you for your full consideration of these matters, which raise several issues of significant national public importance. We appreciate you collectively rendering a thoughtful and just decision for all Canadians. Section 0.3, Background. By way of background, these next 5 paragraphs summarize the circumstances I have faced over the past 4 years. After them, I will focus on the issues themselves. These circumstances were shared by millions of Canadians since the onset of this once-in-a-century COVID-19 pandemic. What began as an unprecedented global crisis gave rise to a cascade of adverse events and decisions. This situation escalated when certain employers, albeit often with good intentions, adopted policies purportedly designed to protect their workforces but that, in practice, violated established legal principles. 2. The absence of historical precedent or proven policy frameworks resulted in wide-ranging societal experimentation as governments, businesses, and citizens navigated the unfolding crisis in real time. This period saw effects on the economy and labor force that were unparalleled in modern history. Measures such as mass quarantines of healthy individuals, the designation of Canadians as essential or non-essential, widespread operational restrictions, lockdowns, and severe logistical disruptions significantly harmed industries across the country. Meanwhile, the public awaited the solution that could flatten the curve and save the healthcare system, so we could all return to normal. 3. The resulting conditions displaced hundreds of thousands of employees and contributed to an extraordinary surge in EI claims. The administrative response that followed was marked by numerous systemic errors, issues so significant that, were their impact not so detrimental to already vulnerable families, they might be described as a comedy of errors. Despite this, these problems have gone largely unaddressed by those empowered to correct them. 4. During this period, laws were disregarded, contracts were broken, and inapplicable case law including outdated and erroneous precedents were relied upon to rationalize these outcomes. This involved selectively citing isolated passages removed from their proper legal context, and employing logical fallacies to create predetermined denial templates. The existence of an undisclosed internal memo and the use of template-driven case management tools compounded the problem. Collectively, these developments have revealed a substantial departure from the legislative intent underlying the EI Act as enacted by Parliament between 1988 and 1996. And 5. This case seeks to draw attention to these legal errors and institutional process engineering, all of which directly affected my own experience along with numerous other EI claimants who were also wrongly denied benefits for these same reasons. It requests corrective action from this honorable court, from the only branch of government with both the independence and authority to address such issues when the legislative and executive branches have failed to do so. Our courts serve as guardians of the rule of law and the ultimate arbiters of justice in Canada. So it is to this court that Canadians look for hope, solutions, remedy, restoration of legal integrity, and proper direction to ensure that this unraveling of justice does not happen again. Section 1, Summary. My submissions are divided into 2 sections. There are 3, but I do not have time to cover them all. 1. A general summary that outlines 6 specific issues, their impact, and the human cost of these errors. 2. The problem, 4 headings, an analysis of what the law requires and was done regularly before the pandemic. 3. The solution, 10 headings, a list of distinct problems occurring throughout this process during the pandemic. I then conclude with brief closing remarks. I now turn to this summary that outlines the errors, costs, and real consequences involved for many Canadians. Problem number 4, error number 11, financial cost of EI process engineering. From Factum section and many cases, EI adjudicators, adapted from paragraph 279 to 303 and footnotes 228 to 244. 7 points at issue for grounds of review and 2 Vavilov principles. Executive summary. Jurisdiction, procedural fairness, and legal/factual errors. In this case and many others, key legal principles were ignored or applied selectively, resulting in reverse engineering of desired outcomes, which violates the Vavilov requirements for fair and reasonable decision-making. Among them, 1. The mandatory just cause analysis under EI Act Section 29, c. 2. Consideration of employment contracts required by the EI Act and Benefits Principles, DBEP. And 3. Application of the KVP framework governing unilaterally imposed policies. Compounding this, tribunal decisions were produced using pre-written Atrium decision templates, containing stock paragraphs, case citations, and analysis blocks that shaped the outcome rather than reflecting case-specific independent reasoning. These templates consistently favored denial, even when doing so contradicted the reasoning used by tribunal members in their other COVID-19 mandate misconduct cases. Each of these issues will be addressed in detail throughout this submission. Let me start with the numbers. The Tribunal's own decisions over the last decade show 3 clear periods. Mid-2013-2019, the pre-pandemic baseline, and using the 2019 statistic of 988 tribunal cases as a benchmark. 2020-21, the lockdown lull. 2022-23, the mandate peak, when EI processed more than 1 million excess claims. Across the full pandemic era, 2020-24, the SST decided 4,943 EI appeals. During the lockdown lull, annual EI appeals fell by 1/3, from 988 to 650. Once mandates were introduced, the caseload jumped 42% above the 2019 baseline and 214% above the lull, from 650 to 1,400 annual cases, the largest spike ever recorded. During the mandate peak, over 37% of all EI appeals were mandate misconduct cases. And outcomes shifted dramatically. Mandate misconduct claimants were denied benefits for 0.23 times more than other claimants, a success rate of 6%, compared with 25%. In 2023 alone, over 41% of all EI appeals at the SST were mandate-related, hardly a fringe minority. These numbers and the modified processes discussed below reveal something unmistakable: mandate misconduct cases were treated differently systematically, consistently, to the detriment of claimants across the country. Here's a brief overview addressing 6 specific matters. 1.6. Just cause analysis, EI Act Section 29, c. Before the pandemic, tribunal members routinely applied this analysis. From 2013 to 2019, over 1,300 decisions included just cause analysis, and about 550 directly cited Section 29, c., with hundreds of claims allowed. 450 misconduct-specific cases received just cause analysis, and 174 were allowed. Before the pandemic, 94 cases were decided on contrary to law or contract-based grounds, including 38 misconduct cases. But during the pandemic, mandate misconduct decisions never applied Section 29, c. meaningfully, and almost always denied benefits. One specific point of hypocrisy. During the pandemic, contrary to law analysis was applied when claimants alleged feeling unsafe at work because their employer did not enforce mask mandates on their coworkers. They were granted benefits. But applying this same test to other mandate policies was deemed ultra vires, or outside their jurisdiction. This comparison shows a clear break from long-standing EI adjudication practices and the statute itself. 2.6. CBA and contract analysis. Before the pandemic, about 350 tribunal decisions analyzed employment contracts, with 126 allowed. During the pandemic, contract arguments more than doubled to over 800 cases, yet the allowance rate dropped sharply. and contracts were consistently ruled inadmissible in mandate misconduct cases. We also see other troubling inconsistencies. For example, 58 cases were dismissed on management rights grounds, even though these rights only exist because of the employment contract the tribunal was refusing to consider. This is not consistent or reasonable statutory interpretation. 3.6. KVP Policy Validity Test. Since 2020, KVP was cited 24 times. Half the time, members invoked KVP to uphold an employer's unilaterally imposed policy. The other half, when claimants correctly argued that KVP rendered these policies unenforceable, those same members suddenly declared KVP ultra vires. KVP was used when it denied benefits but rejected when it helped claimants, an example of outcome-driven reasoning. For 6. Atrium templates, the tribunal used Atrium decision templates that inserted prewritten paragraphs, citations, and reasoning. The result: inconsistent logic but consistent outcomes, benefits denied. This is also outcome-driven adjudication, not independent, fact-based decision-making. 5.6. Tribunal membership shifts. During the mandate peak, EI appeals rose 214%, while the tribunal lost 28% of its members. Shortly thereafter, by late summer 2022, membership jumped by 50%, and mandate misconduct denial rates increased by over 400%. That pattern raises obvious concerns and deserves scrutiny. 6.6. Impact on individuals. Vavilov paragraph 133-135. Vavilov requires decision-makers to consider how their decisions affect people's lives, and include this in their written reasons. Mandate misconduct decisions had life-altering consequences during a national crisis. Yet in my case and many others this mandatory factor was never addressed. Your Honors, the core problem is simple: the law has not been applied consistently or fairly. Before the pandemic, EI adjudicators routinely followed their home statutes and conducted the required just cause analysis. But in mandate misconduct cases, that process was universally rejected. The same selective approach appeared in their treatment of employment contracts, common law principles, and key evidence. Under Vavilov, a decision is only reasonable if it identifies and grapples with the real issues and justifies the reasoning. Fundamental justice demands consistent application of law and fact, not consistent outcomes. Arbitrary use of vires to exclude relevant tests and evidence raises both jurisdictional and fairness concerns under Section 18.14a and b. From the Federal Courts Act, Grounds of Review. Using prewritten templates containing various errors to build decisions also impacts fairness under Section 18.14b. Applying legal principles inconsistently without justification is an error of law under Section 18.14c. And flawed processes overriding the EI Act arguably meets, acting contrary to law under Section 18.14f. For all these reasons, this pattern of unjust decision-making cannot stand. We respectfully ask the Court to intervene and quash the decision as unreasonable. Section 3, Solution, ESDC, Process Engineering. Your Honors, because of time constraints, I won't be able to walk through the full legislative process section today. My filed factum contains 47 paragraphs and 81 footnotes detailing the EI Act, the Hansard record, and the documentary evidence before you, including our RISO analysis of EI Act sections 29 to 33 on just cause, entitlement, and disqualification. This includes the rule of law and jurisdictional issues that arose during the pandemic, and the private and common law principles that govern these cases. They are listed under problems number 1 and 2 in Section B to F. I respectfully ask the Court to consider that material carefully. It sets the foundation for what follows. Understanding what Parliament intended and how EI adjudication normally operated before the pandemic is essential to understanding the depth of the problems we are addressing today. If time permits, I will return at the end to the key tribunal precedent used to dismiss my case. It contains 5 major errors, each sufficient to be quashed. I cannot change the decision, but I can show why it cannot apply to my circumstances, and why correcting that citation definitively changes the outcome in my case. For now, I will move to Part 3, where I briefly outline 10 structural errors that occurred in mandate misconduct EI cases. These are not minor defects. They represent system-wide procedural shifts that displace the proper adjudication process required by the EI Act and the rule of law. And they affected many thousands of claimants. Section 3.1, Employer, Falsified ROEs, Code M. Problem number 4. Error number 9, falsifying ROEs, with intent, potentially breaks the criminal code. From Factum Section L. Employer falsified evidence, adapted from paragraph 237 to 269 and footnotes 181 to 218. 7 points at issue, 3 grounds of review, and 2 Vavilov principles. Section 398 of the Criminal Code makes it an offense to falsify employment records, if there is intent. Since this is civil, I'm not alleging wrongful intent. But my ROE contains a reason code that is provably false. In Block 22 on all ROEs, the issuer swears that, I am aware that it is an offense to make false entries and hereby certify that all statements on this form are true. This is important. If a court acts on fraud or perjured evidence, that is grounds for judicial review under Section 18.14e. If the reason code on any ROE is provably false based on the evidence, those decisions may be set aside. My factum cites 6 sources confirming I was on approved administrative leave. Purolator's final employee bulletin said, employees who are not fully vaccinated will be placed on an unpaid leave of absence and should not report to work. Compare this with Service Canada's special HR guide, ROEs during COVID-19 vaccination. When the employee doesn't report to work because they refuse to comply with your mandatory COVID-19 vaccination policy, use a code N leave of absence. Instead of N, my ROE was coded M, which was false. This denied my EI due to my misconduct. Here are 2 of 6 other warnings from Employment Canada. ROE Guide, Box 16 Warning. It is a serious offense to misrepresent the reason for issuing an ROE. If you knowingly enter a false or misleading reason, you may be subject to fines or prosecution. ROE Guide, Box 22 Warning. The person who is completing the ROE knowingly certifies that the information on the ROE is correct. The term knowingly means fully aware, with full knowledge of the facts. These miscoded ROEs potentially deprived EI of millions of dollars in premiums that employers owed after arbitrations. I respectfully urge the court to consider the consequences of so many EI claimants being issued factually false ROEs, certified documents claiming suspension or dismissal for misconduct when we were all on approved admin leaves. Since ROE codes are the basis for deciding EI claims, widespread, knowingly false, criminally certified documents impact fairness, legal compliance, and the integrity of the EI system. This cannot be accepted, validated, or turned into precedent. Section 3.2, Service Canada and the CEIC, BE-Memo, 2021-10. Problem number 5, error number 12, legal issues with internal BE-Memo overruling EI Act. From Factum Section O. Internal BE-Memo usurps law, adapted from paragraph 304 to 321 and footnotes 245 to 249. 1 points at issue, 1 grounds of review, and 4 Vavilov principles. Vavilov paragraph 95, reviewing courts must keep in mind the principle that the exercise of public power must be justified, intelligible and transparent. It would therefore be unacceptable for an ADM to provide an affected party formal reasons that fail to justify its decision, but nevertheless expect that its decision would be upheld on the basis of internal records that were not available to that party. On October 19, 2021, Employment Canada, ESDC, issued an internal policy named EI Eligibility and Refusal to Comply with Mandatory Vaccination Policy, known as the BE-Memo, 2021-10. It changed how they processed claims, but only for workers in mandate situations. It introduced new definitions and fact-finding procedures that did not exist in the EI Act, including different interpretations of voluntary leaving, suspension, leave of absence, and other key terms, plus new criteria for assessing exemptions. It began with an admission: this memorandum is not linked to any legislative or regulatory amendments. If it has no legal basis, by what authority did it change definitions, processes, and requirements set by Parliament? An internal memo cannot lawfully rewrite the Act, regulations, or case law. For that reason, the BE-Memo and all decisions based on it rest on legally invalid foundations. This raises four critical questions: 1. Who authored it? 2. Who approved its use? 3. Why was it kept internal and unpublished? And 4. Why was it only applied to one subset of claimants? These are core questions of legality, transparency, and procedural fairness. 1. The BE-Memo redefined fact-finding. It provided a new definition of complete fact-finding that removed employment contract analysis from the process. Contracts are the legal basis of all employment relationships and are core to determining eligibility. 2. It conflated approved administrative leaves with disciplinary suspensions. During the pandemic, many employers made the deliberate choice to put unvaccinated workers on approved leave instead of disciplinary suspensions or firing them. They did this for business and legal reasons. There was no lawful basis to reclassify approved leaves as suspensions. EI eligibility must be based on actual employment status, not labels defined by an internal memo. 3. It reversed the benefit of the doubt. The BE-Memo also introduced the concept of exceptional circumstances that placed an undefined burden of proof on claimants. It subtly shifted the benefit of doubt to the employer, contrary to EI Act Section 49(2), which requires that claimants receive it where evidence is balanced. This is not a small change. It reversed a core legal protection. Conclusion: the BE-Memo unlawfully changed the processes governing EI adjudication. It removed contract analysis, invented new definitions, overrode the just cause factors, and effectively replaced the EI Act with an internal, unpublished policy applied only to selected, mandatory vaccination non-compliant claimants. This is procedurally unfair under Section 18.14b. It also violates Vavilov's prohibition against internal records, paragraph 95, and its transparency, consistency, and lawful decision-making requirements. Because EI's staff were bound by undisclosed internal rules, and because the BE-Memo displaced Parliament's authority, we respectfully ask this Court to quash the decision as unreasonable. Finally, we submit that the Court should provide guidance on the use of undisclosed internal policies. Any internal rule that determinatively affects a claimant's benefits must be disclosed publicly without requiring a TIP litigation so its legality can be verified. This is essential to coherent reasoning and meaningful justification under Vavilov. Section 3.3, CEIC, Changing Facts, Leave of Absence is not equal to suspension. Problem number 4, error number 10, EI Commission potentially changing facts of the case. From Factum Section M CEIC, Changing Facts, adapted from paragraph 270 to 278 and footnotes 219 to 227. There are serious legal problems with using terms like suspension and misconduct in ways that don't reflect the factual record or the reality of my employment status. When the CEIC substituted them for the words used by witnesses and documents, that arguably amounted to changing the facts in the case. The only Purelator exec who, quote, confirmed, I was, quote, dismissed, never once used the terms suspended or misconduct. No Purelator employee ever used them, and when EI agents did, they were corrected 4 times. My Internal Service Canada claims file was coded LOA leave of absence from the outset and remained that way until I appealed to the Tribunal. Only when the Commission's decision and underlying evidence was to be reviewed, did they suddenly, quote, discover their, quote, clerical error, and retroactively change my status from leave of absence to suspended due to misconduct. This was the first time the term suspended was used in their record. Changing my separation type from leave EIA Section 30, which requires just cause analysis, to suspended EIA Section 31, changes the applicable section of the Act. They introduce new and used terms that form the basis for an adverse finding. The CEIC record contains 18 statements, from 4 sources, confirming I was on approved admin leave, all contradicting their later finding of suspended for misconduct. This new fact was discovered only after I filed an appeal with the tribunal, appearing ex post facto as a supposed clerical error. Worse, they attempted to justify this by citing a case, saying that an error which does not cause prejudice is not fatal to the decision under appeal. Cit. DeRosier, #A128-89, this proves that errors causing prejudice are fatal. Characterizing this conduct as mere clerical error is inappropriate. That involves harmless mistakes that do not alter the substance of a decision. By contrast, revising a final decision, after issuance, by substituting new findings with different legal analysis, that invokes different sections in the Act, is not a clerical correction. It is a retroactive change to the decision's foundation. No reasonable administrative framework should permit this to stand. Ignoring this is not merely unreasonable. It should be examined whether they changed material facts by doing this. And this problem was not isolated to my file. I can prove it happened to others. It was part of a broader, systemic pattern. Section 3.4, SST, Atrium Templates, Overview and History. Problem number 7, Error number 14, Legal Issues with Using Pre-Written Decision Templates. From Factum Section QR, Atrium Templates Control Decisions, adapted from paragraph 346 to 361 and footnotes 261 to 271. Points at issue, not applicable, 1 grounds of review, and Vavilov principles, all of them. The Tribunal's case management platform, Atrium, builds decisions using pre-written templates containing pre-selected arguments, footnotes, and case law excerpts. By inserting backbone paragraphs that often set out the legal tests in advance, Atrium risks shaping if not predetermining the decision's outcome. Decisions issued during the pandemic prove that Atrium's library includes conflicting templates that embed contradictory reasoning. They enable members to reverse engineer desired outcomes, which our Supreme Court has prohibited. I'll read 3 statements about templates from the Tribunal's published reports and manuals. They raise serious concerns about how they influence decision-making. Report on the Tribunal's Activities and Accomplishments, 2016 to 2017, record page 958. The Tribunal launched 5 new releases of its case management system, Atrium. Tribunal capacity was enhanced with new features, such as assignment tools. Efficiency was further improved with the development of decision templates pre-populated with legislative texts related to the issues at hand. Issues: who approved this pre-selection of case law? Was it reviewable? Who authored the KVP templates? Who can insert them? And who decides when they apply or if they can be overridden? Evaluation of how easy it is to read SST decisions, 2024, record, page 1053, top, and page 1054, impact paragraph 4. This study began to sample their decisions for analysis. Some TMs expressed challenges in applying training recommendations, particularly those delivered by non-legal professionals or inconsistent with templates or internal messaging. Note, the number 1 training support request was for decision templates. Issues: what does it mean for training recommendations to be inconsistent with templates or internal messaging? When there was conflict, what took precedence? Is this internal messaging published, binding, or reviewable? If not, it's like the BE-Memo, a parallel, undisclosed system managing adjudication. Style Guide, Social Security Tribunal of Canada Decisions, Authorities, page 1821 Part 1, and page 1845, top. Part 5, Formatting. Before you start writing your decision, make sure you use the most recent decision template. Using Atrium templates has benefits. They often set out the legal tests. Avoid using an old decision as a template. In Part 1, Writing Strategies, members are further told, a solid structure will serve as the backbone for your decision. The most recent decision templates in Atrium give you solid examples. Issues: TMs are instructed to use Atrium templates. Pre-selecting legal tests predetermines the analytical path, shapes the evidentiary framing and analysis, and influences outcomes. When TMs encounter prewritten templates that are unhelpful, inapplicable, or legally incorrect, they are forced into one of three bad choices: justify, remove, or comply. Justify, departing from the pre-inserted arguments and jurisprudence, risking findings of a quote, inconsistency, distorted analysis, or incorrect application. 2023 SST 1032, CEIC v. AL, paragraph 45, despite its flaws, the GD's decision contains numerous statements of the law that are, on the face of it, correct. I.e., inserted by Atrium in more than one section, the GD accurately summarized and cited a key legal principle, only to ignore or distort it in the analysis that followed. This illustrates the problem: TMs must either conform to inserted text or risk being overturned. How do TMs fix it without compromising their decision? Remove the prewritten content and risk being overturned and its consequences. Comply with the prewritten content, even when they recognize that doing so leads to incorrect or unreasonable outcomes that could become precedent later, once difficult to correct. Pressing questions arise. What happens when templates set out the wrong legal test? Who is responsible when templates contradict precedent? What happens when legal or logic errors are embedded? Can TMs override these templates without repercussion? And how can claimants receive fair, individualized, lawful adjudication when prewritten content plays the backbone role in the decision-making process? These concerns go to the heart of procedural fairness and administrative independence. Templates shape the structure, legal framing, and interpretation in decisions. They influence how members interpret laws, apply legal tests, and construct their reasoning. The presence of conflicting templates containing erroneous or incompatible legal principles only deepens the fairness concerns. See Section 3.9, KVP Templates. It is essential that the development, management, and use of these templates be subject to public disclosure and judicial scrutiny. TMs must retain genuine independence to identify and apply the appropriate legal tests themselves, free from prewritten reasons, mandatory citations, or implicit policy directives embedded in their case management system. Section 3.5, SST, Precedent Error, RE-EI Funding Model. Problem number 6, error number 13. EI benefits denied using erroneous taxpayer impact templates 160 times. From Factum Section P, EI denied on taxpayer grounds, adapted from paragraph 322 to 345 and footnotes 250 to 260. 2 points at issue, 3 grounds of review, and 3 Vavilov principles. Vavilov paragraph 133-135. Individuals are entitled to greater procedural protection when the decision in question involves the potential for significant personal impact, including decisions with consequences that threaten an individual's livelihood. Where the consequences are particularly severe or harsh, a failure to grapple with them may well be unreasonable. The corollary to their extraordinary degree of power is a heightened responsibility to ensure that their reasons demonstrate that those consequences are justified in light of the facts and law. 2 decades ago, a judicial misunderstanding about EI funding overrode Parliament's will in the EI Act. Although originally dicta, other words, the error migrated into ratio, the holding over time. That mistake now lives as binding precedent despite being textually indefensible under the Act. During the pandemic, it was templatized and mass-cited to deny benefits unjustly. In many cases, employers had broken laws or violated their contracts. Yet this precedent was invoked to excuse employer wrongdoing while decision-makers ignored mandatory just cause fact-finding. This was systemic. EI funding model in case law. Both tribunal members denied my EI claim on the ground that, quote, it is not the responsibility of Canadian taxpayers to assume the cost of wrongful conduct by an employer by way of EI benefits, as though I must personally bear that cost, quote, rather than having taxpayers pay for the employer's actions through EI benefits. This reasoning is legally and factually wrong. It originated as an error in McNamara, paragraph 23, in 2007, was repeated in Parody, paragraph 34, and DeBow, paragraph 36, and was later used to deny benefits in 160 pandemic-era cases. After a J4EIM Usprich relied on this rationale, I spent 6 pages of my AD written arguments documenting the legislative history of the EI Act, including its funding model. I cited the Act, Bill C-21, and Hansard's, all proving that taxpayer funding ended in 1990. AD LaFontaine ignored this evidence and repeated the same taxpayer error. I do agree that taxpayers should not pay for employers' unlawful conduct. And they don't. EI benefits are funded only by the premiums remitted every pay period. EI funding model under the Act. The EI Act Section 65-70 govern premiums, and Section 70.2-80.1 govern the EI Operating Account, EIOA. The EI program has been required to operate on a revenue-neutral basis without taxpayer funding since 1990. Surpluses reduce future premium rates, shortfalls increase them. Taxpayers do not and cannot subsidize EI benefits by law. Annual financial reports submitted to Parliament prove that the program meets its 7-year break-even requirement. The structure of EI is straightforward. Workers and employers both pay premiums so that, if the worker has just cause, this prepaid insurance is returned for up to 45 weeks. But when there is no just cause, all premiums paid by both parties remain with the program for others. This makes just cause the keystone of entitlement, and explains why Parliament fought so hard to codify it. Yet because a well-meaning judge misunderstood EI's funding model, erroneous obiter dicta evolved into so-called binding precedent during the pandemic, creating a perverse, unjust outcome. I pay for me plus they pay for me. If I have just cause, some is returned to me. But if they break the law, everything we both paid for me is forfeited to, quote, save taxpayers $0. Under this error, law-abiding workers lose their job, income, and now EI benefits even when just cause exists, while the law-breaking employers incur no added cost. And this is justified on the false premise that taxpayers would be unfairly burdened by paying nothing. This directly contravenes said Vavilov requirements. My livelihood was plainly threatened. Purulator's unlawful lockouts eliminated it entirely. Both members failed to grapple with the severe consequences of their decision, or justify them through intelligible reasons. Reliance on this erroneous precedent undermined both the facts and the law. Factually, it assumed a taxpayer burden disproven by the Act itself. Legally, it permitted them to avoid their mandatory just cause fact-finding duties, thereby excusing Purulator's unlawful conduct. This flawed precedent shields lawbreaking employers while depriving not at-fault workers of their insurance. These are not abstract harms, they destroy the integrity of Canada's national social insurance program. This is the opposite of fairness and justice. It is unreasonable. 20 years of inadvertently repeating this error, even out of sincere concern for public funds, cannot justify perpetuating a mistake that contradicts the Act and harms Canadians. Section 3.6, SST, Historical Cases, Misuse of Process. Problem number 3, error number 6, miscited cases, templates and potential abuse of process. From Factum Section H Historical Jurisprudence, adapted from paragraph 179 to 195 and footnotes 135 to 146. 2 points at issue, 2 grounds of review, and for Vavilov principles. There are 5 federal decisions used to dismiss mandate misconduct appeals en masse. They are paired with the flawed, for part misconduct test, discussed next, to justify the claim that EI decision-makers cannot, quote, consider how the employer behaved, focus on the employer's conduct, or examine whether they breached a term in the contract because doing so is said to be ultra vires in misconduct situations. They are Belovens 331 pandemic citations, Misibanijima 849 pandemic citations, McNamara 593 citations, Lemire 110 citations, Parody 610 citations. Together, these authorities have been cited 2,500 times in SST mandate decisions. And they're wrong. These cases involve claimants who were self-admittedly guilty of real misconduct because they breached their contracts and broke the law. The courts specifically reached misconduct findings because of this, so they cannot apply to us. Problem: if assessing contracts was truly ultra vires, as now claimed, none of these findings could have been made. I did not breach my employment contract, nor was that allegation ever made. Relying on cases where other claimants admittedly broke their contracts to justify denying my claim now is an error in law, for me and for thousands of others. These authorities are cited to justify refusing to conduct required fact-finding. When claimants admit to misconduct, no further inquiry is needed. But the opposite is true when misconduct is denied. It would be absurd and improper for a prosecutor to respond to a not guilty plea by citing unrelated cases in which other defendants pled guilty as evidence of the present accused guilt. Yet this is precisely what occurs here. Where EI claimants admit misconduct, broken contracts, there is no need to investigate just cause. So considering how the employer behaved is irrelevant in those cases. But where claimants deny misconduct, as I did, the EI Act requires thorough fact-finding. This requirement flows from statute, policy, and basic fairness. Members cannot avoid it merely because an employer alleges misconduct, or because some unrelated claimants in unrelated cases admitted their guilt many years ago. Therefore, citing these 5 cases as so-called precedent is not only unjust, it is legally indefensible. Employers cannot unilaterally impose unlawful corporate policies, full stop. It is unjust to allow adjudicators to divorce their citations from their legal context to justify lawbreaking. This cannot be permitted to remain precedent. And like changing facts, should be sanctionable. Section 3.7, SST, Internal Logic and Consistency. Problem number 2, error number 5, legal issues with misconduct test, logical fallacies. From Factum Section G, Internal Logic and Inconsistency, adapted from paragraph 134 to 163 and footnotes 126 to 129. 6 points at issue, 5 grounds of review, and 6 Vavilov principles. Vavilov paragraph 102-104. To be reasonable, a decision must be based on reasoning that is both rational and logical. Similarly, the internal rationality of a decision may be called into question if the reasons exhibit clear logical fallacies, such as circular reasoning, false dilemmas, unfounded generalizations, or an absurd premise. After examining the decisions wrongly invoked to dismiss our cases, I now turn to how this process engineering operates. The principal tool used to deny EI claims in pandemic mandate cases is the composite for part misconduct test. It asks whether the claimant, 1. willfully, 2. ignored or violated, 3. a clear policy, 4. knowing the consequences. This test rests on the faulty assumption that policy noncompliance is inherently misconduct without any investigation. In the 5 mass-cited cases, that label was justified. But when the underlying conduct is lawful, contractual and constitutionally protected, applying that label becomes absurd. It is circular reasoning to conclude that we cannot consider your employer's unlawful actions because you committed misconduct, when the only basis for the alleged misconduct is my employer's unlawful actions. This logic lets employers insulate their wrongdoing from scrutiny by falsely coding M on an ROE. This automatically triggers an irrebuttable claim that reviewing the employer's conduct is always ultra vires solely because misconduct has been asserted, not proven. This framework effectively determines misconduct based on the employer's unlawful actions, while simultaneously using that alleged misconduct to avoid examining those unlawful actions. This makes justice logically impossible. The premise prevents them from fulfilling their duty to investigate whether that employer acted contrary to law. To illustrate this flaw, test any unlawful policy. X, an employer with productivity problems implements a policy requiring employees to work 24-hour straight shifts without breaks, contrary to labor law. When workers reasonably refuse to comply, the employer suspends them with ROEs coded M for misconduct. Under this current approach, those workers still satisfy all 4 parts of the composite misconduct test. They 1. Willfully, 2. Violated, 3. A clear policy, 4. Knowing the consequences. How could any worker qualify for EI? Any refusal to comply with a policy, lawful or not, becomes automatic misconduct. Any legitimate appeals are dismissed with the blanket assertion, the employer's conduct is not a relevant consideration. This cannot be misconduct in any meaningful legal sense. Note, the 48-hour workweek limitation comes from the same law that prohibits using lockouts to compel worker compliance with new policies and employment conditions. Canada Labour Code, Section 169-173 versus
Section 88-89.
Without first determining whether the underlying policy is lawful and contractual, this test provides no meaningful information about misconduct. This form evaluates only policy compliance, not legality. Applying it mechanically to unlawful policies produces illogical and absurd results. It contains two inherent logical fallacies, begging the question and special pleading. The reasoning proceeds as follows. A. The employer terminates a worker, alleging misconduct. B. In misconduct cases, the test is applied. But now, the employer's conduct is ignored. C. The test is always satisfied when a worker refuses an employer policy, lawful or not. Therefore, the worker is always, quote, guilty of misconduct and denied EI benefits. This is faulty reasoning. The employer's allegation creates both the premise and the exemption from scrutiny. This cannot stand. It fails the basic logic, fairness, and law-abiding requirements mandated by Vavilov and the EI Act. More broadly, the notional misconduct test requires modification. To comply with the mandatory fact-finding requirements of EIA Section 29C, and to explicitly account for circumstances where the underlying employer policy is unlawful. Section 3.8, SST, Bad Case Law Pandemic Era. Problem number 3, error number 7, legal issues with COVID-19, specific case law. From Factum Section IJ Current Jurisprudence and Logic Errors, adapted from paragraph 192 to 211 and footnotes 140 to 150. 2 points at issue, 2 grounds of review, and for Vavilov principles. Since post-COVID case law was cited in both my decisions, I must address it briefly. I explained in my AD written arguments why Sachetto, 2023 FC 102, does not apply to my case. T.M. Lafontaine did not engage with any of them. That Sachetto holding is clear. He was denied leave to appeal because he did not raise an arguable case per the Desta. A reason the judge cited multiple times. My case identified numerous errors, each supported by laws and jurisprudence. Citing a decision merely because it mentions COVID vaccination policies is not a reasonable basis to uphold it on review. However, Sachetto's broader reliance is concerning. As of 2025, it was cited over 400 times to deny EI claimants often on their merits, despite his federal judicial review not being decided on its merits. Instead of grappling with my arguments that distinguish its applicability, Lafontaine cited 5 more post-Sachetto cases. Milivac, 2023 FC 1120, Cook, 2023 FC 1134, Matty, 2023 FC 1527, Davidson, 2023 FC 1555, and Francis, 2023 FCA 217. 4 of them explicitly depend on Sachetto, which is circular reasoning. Once I prove that cases Sachetto does not apply, it is illogical to respond with cases BE, when they all dispositively rely on Sachetto themselves. Section 3.9, SST, Specific Templates, KVP. Problem number 7, error number 14, legal issues with specific pre-written decision templates, e.g. KVP. From Factum Section QR Atrium Decision Templates, adapted from paragraph 346 to 361 and footnotes 261 to 271. TM selectively invoked KVP to support blanket denials. Many claimants argued that their employers' policies broke their contracts. Pre-pandemic, this was strong. Many historical decisions analyze contract clauses for violations. KVP first appeared in CHV, CEIC, 2022 SST 1337, where the claimant argued the policy was unreasonable because it failed the KVP test. The TM rejected this, stating that this legal test was developed in the labor relations context and is not applicable in the interpretation of the EI Act. 86 days later, KVP was cited by the TM in favor of the employer. This time, it included a detailed, templated explanation, multiple paragraphs, case law citations, and footnotes asserting that KVP justified the unilateral policy imposition. 2023 SST 31, SSV, CEIC, paragraph 83, in what is generally known as the KVP test, any rule or policy can be unilaterally introduced by an employer, even if the union disagrees with it. The Supreme Court of Canada has endorsed the KVP test. Across mandate-related cases, for recurring KVP templates appear. 2 invoked by members to justify unilateral policy impositions and 2 used to rebut claimants who argued their policy breached their CBA. All 4 come with identical citations and footnotes. Some members change a few words to customize them, but the underlying structure remains the same. These pre-written templates contain significant legal problems themselves. KVP does not authorize any unilateral policy, even where the union disagrees. It imposes strict constraints. By invoking KVP without request, the TM elevates it to persuasive authority, contradicting their earlier finding that it is ultra vires for EI adjudication. When TM cites Supreme Court and labor arbitration cases, it undermines the argument that KVP is irrelevant. These same paragraphs reappear, verbatim, in many other decisions, confirming their template-driven origin. KVP appears in 24 mandate misconduct decisions. All 24 times, benefits were denied, often for contradictory reasons. When claimants argue that their employer unilaterally imposed a policy, a template is used asserting that KVP permits this. But when claimants argue that KVP invalidates unilateral policies that violate the contract, a different template is deployed, asserting that KVP is ultra vires and cannot be considered. This inconsistent, outcome-driven use of KVP, invoked when it supports denial but dismissed when it supports eligibility, is reverse engineering desired outcomes, which violates Vavilov. This unfairness undermines the independence and integrity of EI adjudication. Vavilov paragraph 121, the decision-maker's task is to interpret the contested provision in a manner consistent with the text, context and purpose, applying insight into the statutory scheme at issue. They cannot adopt an interpretation they know to be inferior, albeit plausible, merely because it appears to be available and expedient. Their responsibility is to discern meaning and legislative intent, not to reverse engineer a desired outcome. Template-driven reasoning departs from these principles. Decisions produced through Atrium cannot meet the standard of justification, transparency, and intelligibility required by Vavilov. Section 3.10, SST, Template Problems, Atrium. Problem number 7, error number 15, legal issues with using pre-written decision templates in general. From Factum Section QR, Atrium Decision Templates, adapted from paragraph 346 to 361 and footnotes 261 to 271. There are 4 distinct problems with the Atrium decision template system. All 4 affected my case. Imposed legal constraints. At my GD hearing, TM Usprich limited the scope of my testimony to the misconduct test only, before I was even sworn in, ignoring all my statutory arguments. This premature restriction occurred before any fact-finding took place. Was this her independent choice, or was it dictated by her templates? Template accuracy. My factum identifies multiple legal errors appearing verbatim across numerous EI decisions, indicating they originate from shared templates rather than independent reasoning. Templates perpetuate them. Improper application. Heavy reliance on the same excerpts, repeated across hundreds of mandate decisions, shows that blocks of pre-written, correlated paragraphs, citations, and footnotes are being inserted from templates rather than individually written. This causes key facts and arguments to remain unaddressed in the decisions. Reverse engineering. The selective and inconsistent use of KVP-related templates proves that templates are being used to predetermine outcomes, contrary to Vavilov's prohibition on reverse engineering desired results. In many cases, this templated approach resulted in key facts and pleadings being entirely omitted from the decisions. This is unreasonable, as is any internal system that shapes decision-making in non-transparent ways. Atrium inserts prefabricated content, with some templates provably containing legal errors. Pre-selecting the legal tests inherently influences the outcome. This violates procedural fairness under Section 18.14b. Without full public disclosure of how Atrium functions, and the ability to subject template management decisions to judicial review, this system also violates the Vavilov internal records reasonableness factor at paragraph 95. Section 4, Purelator Specific. Section 4.1, Management Inconsistency. Problem number 4, Error number 8, Purelator Management Problems. From Factum Section K My Case, Purelator Management, adapted from paragraph 213 to 236 and footnotes 151 to 180. 7 points at issue, 3 grounds of review, and 2 Vavilov principles. The record contains key facts about Purelator Management's decisions that prove the unlawfulness of their policy, and the unreasonableness of the Tribunal's findings. 1. 2 direct admissions by Purelator leadership. First, in September 2021, their CHRO publicly stated on their workplace platform that management had absolutely zero intent to make vaccines mandatory. We would never do that and couldn't even if we wanted to. This proves they knew they had no legal authority to create new conditions of employment without union consent. Second, in November 2022, their National Labor Relations Director issued written, final warnings to all non-compliant employees, calling vaccination a condition of employment, while acknowledging again that workers remained on authorized admin leave. These admissions were each repeated twice, and issued despite active grievances and arbitration. 2. Internal inconsistency in enforcement. In the final 4 months before we were locked out, local depot management contradicted Purelator's senior leadership team and their written policy several times by allowing us to continue working when the policy banned us from the property. This inconsistency makes the policy unenforceable under labor relations principles and proves depot managers understood the policy had no legal basis. Purelator could not impose unlawful policies, nor create new conditions of employment without prior union consent. Senior leadership admitted as much in writing. Local management refused to enforce the policy in practice, and actively facilitated non-compliance. 3. Ever-changing deadlines, evidence of arbitrary enforcement. I listed 5 different attestation deadlines, for testing requirement changes, and for different immunization deadlines before unvaccinated staff were allowed to return to work. We also missed 5 deadlines without any policy enforcement through New Year 2022, over 4 months. Instead, HQ kept revising the policy. Nothing happened until after the Christmas rush was over, on the 6th deadline. A simple analogy makes the point. Imagine I borrowed money promising to repay you on January 1st. When I failed to pay, I changed it to February 1st. After moving the repayment date 5 times, I was sued for the debt. What would a judge say if I argued that I was still compliant because I hadn't yet missed the newest date? Would that be deemed compliant and consistent? Section 4.2, Errors at Hearing, SST-AD, TM Pierre Lafontaine. Problem number 4, Error number 8, Errors at SST, Hearing under Judicial Review. From Factum Section K My Case, Purelator Management, adapted from paragraph 233 to 236 and footnotes 175 to 180. 7 points at issue, 3 grounds of review, and 2 Vavilov principles. 1. Unreasonable definition of consistent. T.M. Lafontaine adopted a definition of consistency that cannot stand. Changing policy requirements and deadlines 5 times, often after breaking previous ones, is not, quote, consistent. It is arbitrary and unreasonable. 2. Overbroad definition of new evidence. T.M. Lafontaine struck arguments as new evidence despite being logical inferences drawn from numbers, documents, and facts already in the record. This is basic reasoning. It was especially problematic given that earlier jurisdictional errors prevented these points from being raised sooner. 3. Elusive and erroneous definition of misconduct. Both TMs relied on a faulty definition of misconduct that produced several absurd and unreasonable conclusions, contrary to statute and precedent. 4. Conflicting authorities. What are adjudicators bound by? TMs repeatedly claimed to be bound by authorities that were either inapplicable or contradicted by the EI Act. 5. Unresolved jurisdictional issues, KVP, CBA, and policy admissibility. From the beginning, I raised clear legal questions about my CBA, their policy, and KVP. T.M. Lafontaine even acknowledged them as interesting legal questions, yet they were never answered, another jurisdictional failure. Section 2.4, Tribunal Precedent, CEIC v. AL. Problem number 2, error number 2, many legal issues with SST-AD case used as precedent. From Factum Section D Tribunal Precedent, CEIC v. AL, adapted from paragraph 59 to 63 and footnotes 75 to 78. Overview and summary. A key SST decision dispositively cited in my case contains 5 major errors. From 2023 SST 1032, CEIC v. AL, paragraph 20. Cited in my own AD case, at 2024 SST 26. Paragraph 37, it is one thing to ask whether an express or implied duty exists. It is another to ask whether the duty was validly imposed. The second question falls outside of EI law. Record, page 284. This proposition is unreasonable for 5 reasons. Because it was relied upon decisively in my case, it must be addressed. If left uncorrected, it would entrench several legal errors into EI jurisprudence and convert injustice into binding precedent. 5 separate reasoning errors. 1. Rule of law. This reasoning assumes, without analysis, that the duty was lawful. By jumping from "does the duty exist" to "valid imposition" is outside EI law, the tribunal implicitly finds the duty lawful, even when it was not. That violates the rule of law. Employers cannot impose unlawful duties through policy. And ADMs cannot deny benefits based on unlawful requirements. In short, a company cannot grant itself the right to break the law. This is both absurd and unreasonable. 2. Jurisdiction. Refusing to examine whether a duty was validly imposed means refusing to examine whether the employer acted contrary to law, a requirement under Section 29, c. 11. Because this conclusively establishes just cause, lawfulness must be tested. The tribunal therefore commits a jurisdictional error by declaring that assessing validity is outside EI law. In this context, validity and lawfulness are synonymous. A duty is valid only if it complies with legislation and the contract. 3. Procedural fairness. It is fundamentally unfair to hold workers accountable for contractual violations while excusing employers from their own contractual and statutory obligations. Both parties signed the contract and both pay EI premiums. The tribunal's approach allows denying benefits for alleged worker breaches while immunizing employers who break the same contract or impose unlawful duties. This violates basic fairness principles. 4. Management rights and private law foundations. Determining whether a duty exists cannot be divorced from the employment contract that creates it. Policy binds employees only because the contract establishes management rights. If the tribunal excludes the contract from its analysis, it removes the basis for duty of compliance. How can adjudicators invoke management rights after ruling the contract that creates those rights inadmissible? 5. Logical incoherence. The composite four-part misconduct test, as applied in these cases, contains 2 logical fallacies, including petitio principii, begging the question, and special pleading. This will be examined in detail below in Section 3.7, under Vavilov, such incoherent reasoning is unreasonable. Section Conclusion. For these reasons, the Tribunal's assertion that testing the validity, i.e. lawfulness, of a duty falls outside EI law is incorrect in principle, contrary to statute, incompatible with the rule of law, unfair in practice, and logically indefensible. This was T.M. Lafontaine's primary basis for rejecting my written submissions. Reversing this changes the outcome. Worse yet, this case has been cited to deny 57 other claimants. Over half of them at the Appeal Division. This manifest injustice cannot stand unquashed. Section 5, Closing Statements. Thank you, Honorable Justices, for permitting me to place these major errors into the record. Your willingness to allow me to present a summary of my core arguments has helped mitigate the essential fairness concerns in this proceeding. This case contains numerous errors, 15 across 7 categories. Many are systemic, affecting not just my claim but thousands of others, which is why this matter is of national public importance. I fully recognize the extraordinary caseload pressures and political context in which these decisions were made. And despite any firm language in my submissions, I want to be clear, I am not blaming individual decision-makers. The errors were engineered, systemic, structural, and interagency in nature, not personal. My only objective is true justice. When errors of this magnitude occur, the law provides a proper remedy: employment insurance benefits for those who possess just cause. More importantly, correcting these errors will restore fairness, consistency, and confidence throughout the EI system. In closing, I respectfully urge the Court to carefully consider the gravity of the issues raised in these submissions. Dismissing this appeal would not simply deny me the EI benefits to which I was lawfully entitled and paid into over my 30-year career. It would risk opening Pandora's box, with profound consequences that may be exceedingly difficult to reverse. A dismissal would do more than overlook a series of serious errors, it would effectively validate them. It would transform them into binding precedent for years to come. Such an outcome would, in effect, approve the use of undisclosed internal memoranda that operate as private, discriminatory rules overriding acts of Parliament. I use discriminatory in the dictionary sense. These policies applied only to a definable subset of claimants, no improper motive is alleged. It would authorize internal directives that led decision-makers to break their home statute, the EI Act. It would affirm processes that alter facts, disregard established court procedures, and replace mandatory legal tests with selective sentence fragments lifted out of their proper legal context under the guise of precedent. It would also endorse embedding these errors into prewritten, legally inconsistent decision templates that replaced individualized adjudication, and instead, automatically denied benefits. It would bind members to processes that are procedurally unfair, processes that effectively wield jurisdiction to prevent consideration of relevant facts, binding employment contracts, and statutory provisions. The KVP-style templates alone demonstrate the extent of this problem. The recent pandemic harmed millions of Canadians in countless ways. Hundreds of thousands were denied EI in numbers far exceeding historical norms. Numerous tribunal applicants were affected by the list of injustices described here. For many, the consequences were devastating: loss of livelihood, reputational damage, mental and physical health impacts, marital breakdown, impacts on children, home foreclosures, and more. These are not abstract harms. They are lived realities for many productive citizens. I respectfully ask the Court to fully consider the national public importance and the far-reaching implications of the precedent that will be set in this case. Only this Court possesses the constitutional and legal authority to correct these injustices and to provide justice for those accused of EI misconduct under engineered processes now shown to be fundamentally flawed. Thank you for your patience, your attention, and your thoughtful consideration of the full merits of this judicial review. I now reserve the remainder of my time for my reply to the AG, and to answer any questions the Court may have.
Date: February 25, 2026. Docket: A. 63-24. Citation: 2026 FCA 41. Coram, George Locke, J.A. René LeBlanc, J.A. Elizabeth Walker, J.A. Between. Dale Arnold. Applicant. And. Attorney General of Canada. Respondent. Reasons for judgment of the court. Delivered from the bench at Toronto, Ontario, on February 25, 2026. By Elizabeth Walker, J.A. 1. Dale Arnold seeks judicial review of a decision of the Appeal Division of the Social Security Tribunal, SST, dated January 9, 2024, #AD 23-694, dismissing his appeal of a decision of the General Division of that tribunal, June 8, 2023, GE 23-740. 2. The General Division found that Mr. Arnold had knowingly failed to comply with Purilator's mandatory COVID-19 vaccination policy, and concluded that he had been suspended from his job with Purilator for misconduct, pursuant to subsection 30(1) of the Employment Insurance Act, SC 1996, c.
23.
As a result, Mr. Arnold was disqualified from receiving EI benefits. 3. On appeal from the General Division, the Appeal Division similarly concluded that Mr. Arnold's deliberate violation of the vaccination policy constituted misconduct within the meaning of the EI Act, citing Canada, AG v. Belavance, 2005 FCA 87, and Canada, AG v. Gagnon, 2002 FCA 460, see also Misconduct v. Canada, AG, 2007 FCA 36, at para. 14. Leave to appeal to SCC refused, 31967, September 27, 2007, Zagel v. Canada, AG, 2025 FCA 40, at paras. 6-27, leave to appeal to SCC refused, 41765, October 9, 2025. 4. The Appeal Division made the following observations, a number of which reflect arguments that were before the Appeal Division and that Mr. Arnold relies on in support of this application. Misconduct for purposes of the EI Act does not imply that the conduct in question was the result of wrongful intent. It is sufficient that the misconduct be conscious, deliberate, or intentional. Paragraph 20 of the decision. The General Division's role was to assess, I, whether Mr. Arnold was guilty of misconduct, and 2. Whether that misconduct led to his dismissal. Paragraph 21 of the decision. It was not for the General Division to focus on the conduct of the employer or to consider whether the vaccination policy was reasonable or whether the imposition of the vaccination policy violated the employment law relationship because those concerns fall outside of EI law. The General Division had to focus on Mr. Arnold's conduct. Paragraphs 34, 36, 37 of the decision. Any question of accommodation, violation by Purilator of the law, or the collective bargaining agreement in imposing the vaccination policy, or any violation of Mr. Arnold's human or constitutional rights, is a question for another forum. Paragraphs 38 and 40 of the decision. 5. We are agreed that Mr. Arnold's application must be dismissed. The decision was reasonable, which is the standard on which we must review it. Canada, Minister of Citizenship and Immigration, v. Vavilov, 2019 SCC 65. The Appeal Division's conclusions are supported by the evidentiary record, respect the statutory constraints of the EI Act, and meet the Vavilov threshold for justification. Further, the decision is consistent with the jurisprudence of this court applying the test for misconduct for purposes of subsection 30(1) to a knowing failure to comply with an employer's COVID-19 vaccination policy. While it is true that the facts of each case are different, Mr. Arnold has not convinced us that his case should be distinguished from the recent jurisprudence of this court in similar circumstances. See, for example, Lance v. Canada, AG, 2025 FCA 41, Sachetto v. Canada, AG, 2024 FCA 102, leave to appeal to SCC refused, 41441, February 13, 2025, Sullivan v. Canada, AG, 2024 FCA 7, Kotikin v. Canada, AG, 2024 FCA 96, Palazzi v. Canada, AG, 2024 FCA 81, Cook v. Canada, AG, 2024 FCA 74, Zelkoff v. Canada, AG, 2023 FCA 240, Francis v. Canada, AG, 2023 FCA 217, leave to appeal to SCC refused, 41064, May 16, 2024, and Zagel. Mr. Arnold has not convinced us that this jurisprudence is manifestly wrong so as to permit us to depart from it. Miller v. Canada, AG, 2002 FCA 370, et paras. 9-10, Feeney v. Canada, AG, 2022 FCA 190, et para.
16. Comité interprofessionnel du vin de Champagne v.
Coors Brewing Company, 2026 FCA 2, et paras.
48-49.
6. On appeal, Mr. Arnold maintains his argument that both the vaccination policy and Purilators' conduct in imposing and enforcing the policy were unlawful and must be addressed. In his view, to do otherwise undermines the rule of law. However, the Appeal Division reasonably concluded that these issues are beyond the scope of the SST's mandate under the EI Act. They must be addressed by other decision-makers and under different statutory regimes. As this court has said, ere the applicant's submissions to be upheld, the Social Security Tribunal would become a forum to question employer policies and the validity of employment dismissals. Under any plausible reading of the legislation that governs the tribunal, it is a forum to determine entitlement to Social Security benefits, not a forum to adjudicate allegations of wrongful dismissal. Sullivan et para.
6.
7. Mr. Arnold also asserts that the General Division's use of template language was procedurally unfair. 8. We do not agree. The Appeal Division correctly found no unfairness in the use of template language by the General Division in this case. A court assessing procedural fairness must ask whether the procedure was fair having regard to all of the circumstances, including whether the party knew the case they had to meet, had an opportunity to respond and had an impartial decision-maker. Canadian Pacific Railway Company v. Canada, AG, 2018 FCA 69, et paras.
41-54.
As the Appeal Division stated, the General Division held a hearing, listened to Mr. Arnold's arguments and issued a detailed decision based on the evidence and Mr. Arnold's arguments, most of which were outside of the General Division's jurisdiction. It is clear that Mr. Arnold had full opportunity to present his case, and it is equally clear that the General Division listened to and understood his arguments. The fact that certain of the same paragraphs used by the General Division in this case appear in other decisions does not create unfairness or raise a reasonable apprehension of bias. 10. For the foregoing reasons, we will dismiss the application for judicial review without costs. Elizabeth Walker, J.A.